Yet you've muted the sound of the video.
And are you asking me?
No, I was asking Bridget. But it's okay.
The weight is. Watu on tema.
The main part for this, but let's have a look on
Good afternoon, everyone. I hope I'm audible.
Yeah, sure, you're audible.
So I bring greetings from the Uganda National Chamber of Commerce. My name is Moses Okwalinga.
We've lost you.
Mr. Moses, you're mute. We can't hear you.
Okay, sorry, I turned on the camera and muted the microphone. Okay, good afternoon, everyone. My name is Moses Okwalinga. I serve the Chamber of Commerce as the Secretary General. I'm glad that several of our members and members of the business community have joined. I would also like to thank our colleagues from SIAB, with whom we are partnering to bring this event, this webinar for the business community. We're supposed to start at 2 p.m. It's 8 minutes past 2, so I think we can begin, and the rest will find us along the way. Let me also ask the team from SIAB to introduce themselves.
I hope I'm clear.
You're very clear.
Yes, my name is Isaac Sekabanja. I'm a member of SIAB. An arbitrator and one of your panelists today.
Okay, thank you very much, Isaac. Any other member from SIAB?
I think Lillian needs to unmute and come through as well. Yeah, please.
I'm Kiza Lillian, a fellow in arbitration, and I'm one of the panelists today. Thank you.
Okay, thank you. Our partners from SIAB. National Chamber of Commerce is currently in talks with SIAB on entering into a partnership, where we shall work together to support the business community by offering, making available arbitration services, which are faster ways of resolving commercial disputes, among others, engaging in trainings, building capacity, among others. So we're excited about the partnership that we are discussing, and we shall be updating you later on how far we've gone. But it's a partnership that us as a chamber believe is very beneficial for both the chamber and our members, who are mainly business members of the business community. So allow me ask someone from the SIAB to talk briefly about SIAB, so that then we dive into the session.
Good afternoon. I would like to ask our Honorary Secretary, Mr. Kenneth Akampuria, who is online, to say something about SIAB and its history, and then Moses, you can continue.
Good afternoon, everyone. If I was in the olden setting, I would say I've been ambushed. But I'll consider. Apologies, my video can't go on now. Otherwise, the connection will be interrupted. I want to thank all those who've logged in. SIAB is a chapter of the Chartered Institute of Arbitrators of the UK. I hope I'm audible. Are you able to hear me?
Yes, we can hear you.
Okay, excellent. So we've been in existence for close to 2 years, and we are about to celebrate another anniversary. Hopefully, maybe early next year, we may be transforming from a chapter to a branch. Right now, we are fathered or mothered by the Kenyan branch, and we are, I think, the holding institution, if I would say, right now, that is the anchor of arbitration in terms of training and accreditation. We have those who've just completed the membership course, and we may be launching a fellow course also next year. So Mr. Isaac Sekavanja is a member. Madam Lilian Kiza, she's a fellow. So many of us are aspiring to become like Madam Kiza, become a fellow. Our chairperson, Mr. David Kagwa, I believe is also online. He's a fellow, and we are available and very honored to partner with the Chamber of Commerce. I don't want to eat into the time of the presenters, but briefly, that is who we are.
Okay. Thank you very much, Ened and the team from SIAB. I made an assumption that all the members online are our members, so they know a lot about the Chamber of Commerce. Maybe I'll just say something briefly. We are the oldest private sector association. We initially started as a public chamber in 1933, set up by the then British colonial government. And we've later evolved into a private chamber, but we still work closely with government. We currently have 5,000 paid up members, but the database has more. And with the membership from all sectors, we are multi-sector with presence in 129 districts. So you'll find that in almost every district, we have a chapter which has a leadership in the district and supports the business community within that district. We offer various services, including advocacy, creating linkages to external markets. This year alone, we've taken close to 48 delegations to other countries, business delegations at the invitation of other chambers and diplomatic missions to take members for trade fairs, business exhibitions, among others. We also offer, we also issue non-preferential certificates of origins to exporters, which is a requirement for export, but with emphasis, non-preferential. The preferentials we don't issue because they're usually negotiated agreements between member states. We do capacity building for our members. We advocate for reform within the sector, among others. So I'm glad that our members, we have over 50 members of online, and we're expecting more to join. And I'll dive right into the discussion on why we're here. We felt that we would start with the basics, so that we don't give so much information at the beginning, but we believe that with the basics, the business community who are our members will slowly understand why these services are required, why arbitration over going to court, the difference between arbitration and mediation, among others. So then they begin embracing. From statistics from the judiciary show that over 1.5 trillion shillings is tied up in court cases. That's just the commercial court. And on average, the case backlog at the judiciary is estimated to be at about 80%. And the level of turnaround for dispose of a case is between 1 to 4 years. So it shows you that despite all the best efforts from the judiciary, we still have a long way to go to ensure efficiency in our court systems. So avenues such as arbitration, mediation are being encouraged, mainly for the business community because they are faster, to resolve disputes. So SIAB, which is international and has various chapters, was glad to partner with us so that we bring this information to the business community. Let me quickly dive into I'm going to be your moderator for the day. So for our members who have questions, you can send your questions through the chat, so that then we shall give you an opportunity to ask your questions, but also respond to the questions in the chat. So that then we have an engaging discussion. So right into Lillian. We've had all this fuss about arbitration, why it's better than litigation. What is arbitration exactly for the business community? Assume that you're talking to a trader in Chukuwo, a trader at Womb Street, who has the basic information who has lots of information about business, but very little understanding of the law. What, in a layman's language, is arbitration?
Thank you, Moses. Well, good afternoon, everyone. Arbitration is an old age method of settling civil disputes where parties in a dispute agree to present their grievances to a third party, who is usually an arbitrator, for purposes of resolving their dispute with an intention of being bound by that decision that will be handed down. So you'll find that in arbitration matters, the parties who are having a dispute have two ways of having an arbitrator appointed. An arbitrator can be appointed by the parties in the dispute themselves or by an institutional body. And it is always very apt that the arbitrator that is chosen is knowledgeable in the subject matter, and that is the dispute. And with arbitration, we always ensure that there is impartiality so that a judgment is rendered down in accordance with the merits of the case. So pretty much arbitration is settling civil disputes in an alternative way other than going for litigation in court.
Thank you for that clarity. Now, there's been discussions and on various forums. Some people say mediation, some people say arbitration. Well, someone says they can't hear us well. Maybe we might have to speak louder. So there have been discussions. I've been hearing people saying arbitration, others say mediation, and other forms of alternative dispute resolution mechanism. Please explain to us the difference between these various forms of dispute resolution mechanism.
Okay. Arbitration and mediation are two forms of alternative dispute resolution processes. They are used to resolve disputes outside the traditional court litigation. However much similarity they have, there are always differences in the two. And the key differences are, usually I'll mention one of them. In arbitration, you have a binding decision that is handed down by the arbitrator. Whereas in mediation, there is no binding decision that is handed down, majorly because the mediator's role is to facilitate the parties who are having a dispute to reach a consensus, which they may be bound to follow or not. This is different in arbitration. Arbitration, it's a decision, it's registrable at court, and you execute. And yet this is not the case with mediation. Also, the level of control by the parties in arbitration is different from that in mediation. Whilst in arbitration, whilst in mediation, where the parties have control over the processes, because they are negotiating. So they have control over the negotiations, and the mediator simply enhances the negotiation so that they reach an understanding. It's different with arbitration, given that in arbitration, they submit their evidence and claims before the arbitrator, and the arbitrator makes a decision. that's binding on both parties. This is not the case with mediation, because in mediation, they may reach a consensus and choose not to follow or abide by the same. Another key difference between the two is formality. Mediation doesn't have so much formalities like it is in arbitration. Arbitration, there are formalities right from the start, because they have an arbitration clause that stipulates what laws to follow, who to appoint, which law to apply. So there are formalities in arbitration as compared to mediation, where there are no formalities, and the mediator's role is simply to facilitate the parties to reach a consensus. Also, when you look at mediation, the mediator has a neutral role to play. He or she simply facilitates the parties to reach a position of agreement. And yet this is different in mediation, in arbitration, given that the arbitrator will listen to the evidence and make a ruling or hand down a decision, which we call an award in arbitration, and therefore the parties' roles are limited. So the differences also go to the extent of confidentiality. In mediation, the two parties are there listening with the mediator. There is no need for lawyers, but in arbitration, there may be need for lawyers to come in, expanding the scope of who listens to their issues that are in dispute. And you'll also find that the cost implication in arbitration is a bit lower, in mediation is a bit lower compared to arbitration, given that here are negotiations that can be reached in a day or two, whereas arbitration, there are formalities. You file your complaint, you agree on the timelines, and then you also have to pay the arbitrator's fees, which is sometimes set by the institutional body. And if it's not set by the institutional body, the parties, if it's ad hoc, if they have appointed the arbitrator on their own volition, the arbitrator sets the costs that will determine the entire process. So there are differences in the two ADR processes, but they are not too distinct, if I may say, because they all maintain at least some, they maintain some business prosperity between the people in dispute, but the key differences are there, as I've mentioned. So your take homes should be that arbitration gives a binding decision. The level of control by the parties in arbitration is low. The formalities are more in arbitration, and the role of the neutral party is more pronounced in arbitration. Thank you, Moses. I hope that answers the question.
Yes, Lillian, thank you. You've mentioned, let me pick up from something that you've said and engage Isaac. Lillian has just said that arbitration is binding. What makes all parties, if I have a dispute with Francis Tumweside, whom I see online, and we go for arbitration, what guarantees do I have that Francis will respect the decision and that I can enforce the decision arising out of arbitration? Isaac, over to you.
Okay, thank you, Mr. Moses. Good afternoon, everyone. See, what you have asked is more of an enforcement question. And enforcement, as far as the methods of alternative dispute resolution is concerned, starts in what I would call more of two stages. Imagine that if we came to arbitration, and with the arbitrator's engagement, you realize that you value the business relationship and you enter consent. Now, wherever parties consent on something, it is more of they are entering something they have agreed to perform. So there, enforcement is not an issue. You will have a consent award, you will go and execute happily thereafter, having resolved some of the key dispute lines. Where that fails, the arbitrator then will make the award, which is written, and give some parties, will make a decision that puts one at liability to perform certain things legally. Now, because they have been parties, they will get the decision. They have the option to opt to act, or you have the option, if they fail, to go to the High Court of Uganda for enforcement, and you file an enforcement application. But remember, oftentimes in this process, we endeavor that the parties are key in the engagement. They own the process. So oftentimes, whatever comes out is something that enforcement is not a problem. It is always an issue of how well they have owned the process, and they will always find it easy to pay up. You'll even find less disputes on the enforcement part because the process has been well owned up and it becomes easier for them. That's the best I can give you for now. Moses, you can come back.
Okay, sorry, thank you, Isaac. I'm still with you, Isaac. At the Chamber of Commerce, over 60% of our members are SMEs and MSEs that operate fairly small businesses in are not very large corporations. How affordable is arbitration? What do the
Moses,
costs look like for an average dispute?
yes, Moses, that question is very pertinent for many that want to engage arbitration. But I will approach it from a very contextual level of, for everyone that is small today, aims to be big tomorrow. No one starts a business and their aim is to remain small. And if you want to grow and become big, your initial steps, how you manage relations and how you build from the small relationships you have, means a lot as you go forward. So I have a conviction that there is no SME that is building relationships and wants to lose them just over a small dispute, and tomorrow you end up with no clients. So the case of affordability is highly informed by what is at stake. Arbitration is very affordable, but I would not want to start throwing around figures because of one simple issue, is that someone will tell you, Amat, I need something cheap. But what is at stake is actually the lifeline of the business. It's like having a terminal illness, for instance, kidney failure, and you want to treat it with aspirin, and you get a general doctor. That doesn't help you. So for us, ours is a case of specialties, that you might be an SME, but the contract you took on is actually a break or make kind of engagement. So it is important that when you are engaging in that subject, and you get the right skill set, that skill set that will make you get to your next point. And that's where us that come to resolve disputes come in. We are not only trying to give you a cheap service, but we are giving you value for money. So I think, Moses, the best whoever engages arbitration must question the issue of value for money more than the affordability, because oftentimes you might get something that is affordable, but it's not value for money as far as the dispute at hand. Just like many, I'll give an example, many will go to court. You leave, you have a judgment, but you have lost out on the relationship. Where arbitration comes in, one of our key tenets is that we endeavor to preserve business relations. We know that every businessman labors to create those connections. And for them to remain long in business, they still want those businesses, those connections, to be around for a long period. The MTN you see today prides himself with clients that they started with when they were coming to Uganda, but they're also onboarding new clients. So meaning your growth is embedded on how many people you retain and then the many that join you. So I think for us, the case of availability is what we don't stress over so much. We focus more on value for money. And once you give someone value for money, whatever you think is not affordable then makes sense. So arbitration is very affordable. We don't want to lie to you that as arbitrators, we shall charge you $1 billion in a contract.
This mediation must move to 12:30. There has a matter.
Someone is interrupting. Please mute.
These people,
I would want to make it clear that we are very mindful of the price at stake, and the fees charged are commensurate with the value of the dispute. That might cover the affordability. But instead of focusing on what is cheap, let us focus on value for money. The moment you feel that you're getting the value for money, I want to assure you, you'll pay the money without thinking twice. I think, Moses, I think that's enough for your question.
Thank you, Isaac. Lillian, earlier you said you kept on saying it's faster, it's quicker than court, than litigation before courts of law. On average, how long would an arbitration matter take?
Well, we can draw inference to Section 31 of the Arbitration and Conciliation Act, that's Cap 5 of the laws of Uganda, which mandates the arbitrators to make a decision within 2 months from the time they have been called upon in writing or notice to enter a reference. And this period is only extendable by an extra month if the arbitrator has not yet been able to hand down their award. So if you compare this to courts, it is super faster because within 3 months after filing a suit in court, you don't even have a date. You probably are still waiting for the response from the other party in form of a written statement of defense. And even when it's filed, though we are given 15 days to respond, there will be preliminaries to handle. So these preliminaries could probably throw you into another 6 months, without forgetting that the diaries of the judges are usually full. For instance, right now, if you went to court to get a date, you'd be probably given a date next year in September. And whereas if your disputes you had contemplated to settle your dispute by way of arbitration, you'd be singing away with an award in 3 months' time, 2 months' time, or 3 months' time maximum, which takes you to, let's say, March. So it's faster as provided by the Act, and going out of these stipulated 90 days, which is maximum after extension, there ought to be an exceptional reason as to why it should be, but maximum is 90 days and the statutory period is 60 days. That makes it pretty faster, Moses, doesn't it?
Okay, thank you. Now my good friend Isaac. Our members of the business community have unique disputes, and a number of them are with government agencies, URA, disputing assessments, with KCCA, with various government entities, duty bearers. Does arbitration also apply to such disputes?
Thank you, Moses, for that question. Arbitration applies to very many disputes as long as they are contractual in nature. So as much as you have a contract with that particular entity of government, and in your dispute resolution clause, you include arbitration, you are good to go. So and freedom of contract, if we go back into our basics of contract law, allows parties to agree on as much as anything which is lawful. And agreeing a method of resolving disputes is also a lawful means. And KCCA or URA, unless there are other laws that limit you. But for as long as you have a contract with them, you supply the service or supply commodities, you are good to go with agreeing with them. Because you see, arbitration, it's not one-way traffic. If the other party does not agree to it, it's a bit limiting. But if both of you agree and you have a contract cases here and it's agreed, it's good to go. You will arbitrate the dispute. Now, the uniqueness of disputes is not a limitation on arbitration, because amongst the membership of, let's say, CIAP and some of these arbitral institutions, they are highly skilled members who have both academic and practice knowledge. Some of these members are business men and women who have exposure in the industry. And to make it easy for you, they are also Ugandans who will add value to the business perspective of how things are done in the Ugandan way. So to answer your question in the simpler terms, as long as you have a contract with them and the dispute resolution clause is included that covers arbitration as a means of resolving a dispute, you are good to go. There are no limitations.
Still with Isaac, while talking about UNCCI, I made it known to you that we have a presence in 129 districts. Now, the services, Isaac here, Lillian is in Kampala. Will our members who are in Moroto, who are in Chisoro, who are in Kasese, benefit from such services?
Thank you, Moses, for that question. One of the tenets of arbitration Lillian talked about is the less formal nature, and then on top of that is the flexibility. For us as arbitrators, even if I'm stationed in Kampala, but we have what we call the arbitration seat. If in your contract you choose Chisolo as the seat of the arbitration, and also the venue of the arbitration, what refuses an arbitrator from showing up at that venue? If you say we are using Guru Inn as the meeting point, that is the venue. The arbitrator, if they agree to arbitrate that dispute, they must factor in the time when they will travel there. So accessibility and where you are is not a problem. It's actually very easy for us as arbitration because we are like a court. We are not like courts that sit in particular venues. We actually sit anywhere the parties have agreed. So accessing our service is very easy for wherever you are. I think that answers your question.
Okay, it does answer my question to a large extent. I want to pick up on something that you mentioned, that if the parties include it in the arbitration clause, for our businessmen who are trading, we have a number of instances where they enter into contracts, handwritten contracts. How does one ensure that when there is a dispute in my contract, I can apply arbitration at the point of making the contract?
Now, you see...
and does it apply to verbal contracts as well? And gentleman agreements?
This is where we shall start with the basics. You have asked, I will start with the end in mind where I've ended. It is very hard. The Contract Act is very specific on matters concerning how a contract, who should have a written contract. That is a person who has anything they are contracting that is above 500,000. Now, that is a matter of subject value. So it's very important that many of our businessmen understand that as much as you go past 500, something must be in writing. Now, as it is being put in writing, whatever format it is, you might have to engage a technical person, a lawyer. Your lawyer, who is a technical person guiding on that contract, will be the one responsible to make sure that you have arbitration as a dispute resolution. You might inform them what you want, and they must now gauge the technical aspects in that clause. So it is important that as your members form whatever agreements they are forming at any level, that this webinar might give them the knowledge, but they also, we are not trying to be like we are giving medicine that if after this webinar you don't need another person. No, we are simply interesting you that and giving you alertness that once you meet up your lawyer, interest them that is this arbitration. Now, whoever you are, anywhere in the world, we have countries that are pro-arbitration. Whatever nature of contract you enter in, even if you're exporting from Beijing or Doha, you can engage the teams, your team and the other side you are dealing with, that in case of any dispute, we want an arbitration clause. And there you also have control of the venue where you meet. That is all saving you on costs and also the timeliness of handling the dispute. So the arbitration is not limited in nature. It's a matter of those that are agreeing to meet to be in the contract, understanding that the value of what is at stake and whether this method works. And the method, whether the method would work for your dispute, I cannot force it on you now, but it is also going to be an issue of the quality of technical expertise you have hired to guide you in your contract. So even if your businessmen are, and it might be an informal sector, my humble appeal to them is that they don't need to move alone. They must also engage technical people. And at that level of an technical engagement, they can also put in their wish list and say, okay, I think arbitration, I would want alternative dispute resolution for this contract because of ABCD. And that is where it all starts going. Then you come to us as arbitrators once appointed. I hope that answers your question, Moses.
Thank you. To pick on from what you've said, and also from something that I've seen in the chat here, is it possible for some of us who have disputes before courts of law that are not moving, for us to move a dispute from the courts into arbitration, even though our initial, let's say, agreement didn't have a clause on arbitration? When I see that the case has taken a long time, can I come and say, well, Isaac and Lillian, I want to go for arbitration. I don't want to proceed with court.
Now, Moses, that's a very good question. Now, you see, in resolving disputes, it's a matter of skill set at hand. For starters, it is possible that you engage the other side and tell them, you know what, we have wasted a lot of time in court. Can we agree to go to arbitration and notify the court? If they're in agreement, it is possible. And oftentimes when you meet our bench is pro arbitration, they will easily accept once they see the parties are in agreement. However, I must warn you on the other technical realities that oftentimes when you don't envisage this process at the start of your contractual relations, it is going to be a very hard task for you to convince the other party that you need the faster method, because the delay in the court could also be a strategy for the other party. They don't want this dispute to be resolved faster. The more it takes on in court, the more they get to either utilize the money that is involved for other business engagement, and they get value for money from it. Remember, oftentimes our courts will not award you time value of money kind of damages. So you as a businessman, you ought to be alert that at the beginning, you know what saves you your time, the value of your investment, what safeguards. Because at that time when both of you are fighting, there is one who doesn't want to see the dispute end. There are also those, if you tell them that this dispute is going to be resolved faster, more so let's say the legal technical people, some of them enjoy what you call them, the reimbursements that court will give you today. we had a hearing that is 100K. Now, that daily money, they are also lawyers, but they're also in business. Matters a lot. So you might be also cutting down on what they would expect from the dispute. Because I want to tell the businessman here that oftentimes, for those of us that are in alternative dispute resolution, we have realized that disputes end up where they are because of the quality of technical expertise you hire and how engaged they are to give you a fast solution. Some have a mentality that the longer the dispute stays, the more money I get in costs. So such kind of mentality is up to your vigilance to save. Don't think that courts also don't handle disputes a bit faster. But at times, even us as the technical people, we are a party to contribute. That's why we engage the businessmen that are alert here, that you give prevention is better than trying to cure later. Prevent the dispute, prevent this long stay in the courtrooms by opting for alternative dispute resolution a little early. Because later on, where you are in court, you are the mercy of the other party. If they agree, you are lucky. If they don't, you stay there as long as they feel that they are now safe to engage with you.
Thank you, Isaac. Now, Lillian, I want to pick up from your last response, why you were talking about the process, how long it takes. What are the exact processes involved in just for us to get an understanding, us from the business community? If I go for arbitration, if I engage, what do I expect? Briefly describe the steps so that I have an understanding that, okay, when I go for this, I go and bring witnesses, we go and visit locals, things like that. What should we expect when you go for arbitration?
Okay. What is expected from arbitration proceedings? Of course, from the onset, like Isaac mentioned, there should be a well-defined dispute resolution clause in an agreement or in a document that refers to that agreement. The parties should be sure that they have clearly indicated without ambiguity who the arbitrators will be, how they will be appointed, what laws to follow, the venue, the seat and the laws applicable, because if you don't consider that, then there will be a lot of ambiguity and it becomes a problem. So once the parties are unhappy or a dispute has arisen, it's referred to, the parties have to communicate, appoint an arbitrator. They can choose to either appoint the arbitrator themselves upon agreement or choose an institution. We have SIAB, we have CADA in Uganda, which can appoint arbitrators or court. Once an arbitrator is selected or appointed and responds agreeing to the appointment, then you delve into commencement of arbitral proceedings, which start with a statement of claim that is usually called, to be called a plaint in court, but here it's a statement of claim, which is submitted, filed, and then there will be a response from the other party. And then there was usually a preliminary meeting that is held by the arbitrator giving timelines in which certain things will be done, e.g. filing of evidence, production of documentary evidence to determine how the proceedings should be carried out, and all the parties have to abide by all the timelines given. So it is a hearing that is conducted within the timelines of 2 months. And of course, the arbitrator has to make sure that they are impartial and there shouldn't be communication directly to each party. There should be general communications to avoid impartiality. So evidence is listened to by the arbitrator, who then hands down an award after considering evaluation of evidence. And when the award is handed down, then you're ready for execution. You register it at court and execute. To add on that, I wanted to tell you that arbitration is faster in the following ways. It's not gagged with many formalities. You find that in court, they'll give you timelines which are very long sometimes. And if the other party does not comply, court will give more time so that the person is able, they expand the time so the person is able to comply. In arbitration, they are a bit strict. So the timelines are either complied with, or since it's a shorter time, they'll give you less time to comply. Also, the fact is that the flexibility enables quicker hearing. You find that if the person can't file on Friday, they can file on Tuesday. If they can't file on Friday, maybe they should make sure that by the next hearing date, they are ready. So those flexibilities help with quicker hearings. And within arbitration hearings, you'll find that there is limited document production. Sorry, Mary, you're saying something? Yes, going on, the arbitrator is expected to be an expert in the subject matter so that he or she is able to give a judgment which is based on the merits of the court or of the matter. You're also expected to have standardized rules and procedures, and these are prescribed at the onset from the arbitration clause or arbitration agreement that is usually agreed to by the parties prior to any dispute being in place. So you'll find that in arbitration, depending on what rules the parties choose, it is expeditious, and within 20 days, within 2 months, you have your award, or 90 days. And then the same is registrable. You execute and enforce the same and then get your benefits from the judgment. So whoever goes in for arbitration should expect to have an award that enables them recover what is owed to them. Moses, does that answer your question?
Yes, it does. Thank you. Thank you, Lilia. Isaac, for us, the business community, when we are watching TV, when we are before TV and the media, that's why we see how good the lawyer is. The cases they are winning. Then we say, okay.
Moses, we have lost you. Moses? Yes, Moses.
Or maybe as Moses comes back. As Moses comes back, I would also like to tell people in this forum that there are ways arbitration can be fast-tracked, as we have some regulations that provide for fast-tracked arbitrations, and these can be factored in your agreements when you're drafting them. So you could decide to adopt the ICC expedited procedures, which offer an expedited procedure, and in essence, it reduces costs and increases efficiency. Jen, I think you may have to mute your, I can hear you. So when you adopt the fast track, the expedited procedures, it increases efficiency and also reduces costs. And we also have advantages within arbitration, which we could call bifurcation. Bifurcation is where you separate issues and then consider the case on its own merits. Now, this helps, it's usually used in international commercial disputes and large-scale contract disputes. Its advantage is that it streamlines the arbitration process and saves costs. So at all means, it would be very apt for us to adopt arbitration, especially in big commercial transactions and smaller ones for purposes of having quick results, minimizing costs, and also getting the awards quickly so that we benefit and you have a high turnover of your monies that may be held somewhere. Isaac? Isaac, are you there? I think we
Yes,
lost
I'm on.
Moses. Yes, I think we lost Moses.
I don't know where you know. Lillian, for me, the basic of what I would want because according to the question she left, she was asking something about the business community determining a good lawyer by virtue of what is seen on TV. And for where we stand as lawyers, we are not, our service at times, yes, we have to market ourselves, we have to do all those things. But the reality of things is that we don't do show business. And since we don't do show business of trying to appear like we are all over the media and whatever, it's upon you, the businessman, to know what you need in a lawyer and you look out for that. It's always disturbing for our people to imagine that the skill set of lawyering we have and how many people have tried to improve themselves and add on value is not relevant. For them, they will just imagine that every business engagement they have, any lawyer can perform on it. However, at times, some of us, even if you're an informal person, you're engaging in technical business. You have the money, you set up the factory. Now, at times you need to ask yourself, if I'm getting legal skill, which kind of lawyer is going to help me? Does the lawyer have a good understanding of the business narrative I'm in? If that is the case, you are good to go. But oftentimes, if you go for so much TV and whatever, you risk having the classic case of that empty things make a lot of noise. You might end up with someone who was given a microphone by media personnel. They can speak on any subject matter. They don't have any reputation at stake. But even if they spoke wrong information about whatever subject they talk about, for you might think they are being brilliant until you find technical people that can align their expertise to your business. You are good to go. So you as a business person, you have a duty, and you also have a duty to engage multiple legal experts on the different aspects of your business. It is not always that you'll have one lawyer that is like one size fits all. No. The more you will engage some of these very big companies, you will find that they have a number of lawyers on retainer because they know two heads are better than one. That is going to help you to overcome some limitations one person has by comparing what the other has. It comes at a cost to the business, but I want to assure you, you will learn to save money by having the right decisions taken. Because if you invest in the decision-making process that has been well guided, you also reduce on the risk that will come thereafter. So for us as lawyers, ours is to skill ourselves and also tell you, I can offer you ABCD. You also have a duty to also be certain to ask for certain things. That's why entities like SIAB exist. They will give accreditations and certification to lawyers that are in the space of alternative dispute resolution. So you might ask one of your legal experts, are you a member of SIAB, as a way of trying to understand how intentional they are about becoming skilled in the field of alternative dispute resolution. these qualifications or memberships and societies don't exist as a mere show off, but it's a more of a guild of men that think the same. So for us, it's the case that as I'm a member of Uganda Law Society, which shows that I've started the law degree, it's also important that for you, you understand that on top of that, we have become members CIAP. It's not a waste of time, but it's a way to tell our clients that, you know what, I'm also passionate and knowledgeable in this area. So if you need a skill set that is going to help you in dispute resolution, you are safer engaging with lawyers and other professionals. Because remember, CIAP is not all about lawyers. I need to tell you, it's a multitude of professions because accountants have disputes as far as they are issuing out their accountancy work. Tax professionals also engage in disputes when they are engaging with URA. And URA lately has a department on alternative dispute resolution where they mediate tax disputes with you, the client, so that you don't waste a lot of time in a matter that you could have settled by talking over things and also either agreeing installments. So the skill set in our society or in our membership as CIAP it cuts across. We have engineers, we have accountants, we have surveyors, because we understand that for every professional practice comes with a dispute. Those disputes are to be resolved by people who are technical in the subject matter, but also on top of being technical, they have been trained in the art of alternative dispute resolution. They are not scared to engage and also get the parties to work together. So for you as a business person, wherever you sit and wherever you are, you have a duty to identify the best skill set because that's what is going to make you compete comfortably with so many of your other business partners. Imagine going to a dispute with a pseudo lawyer or a quack lawyer. Oftentimes, the level of engagement and level of analysis is going to be bad. I have seen lately, we have a practice where people fail to hire lawyers and they say, I can go with full figure because they think lawyering is either for making noise, shouting and insulting. No, for us, we are your strategic guide people who are going to tell you, I think in these circumstances, shouting does not help. Don't you need this relationship? Yes, you need it. I can even show you the numbers and tell you, you know what, this is a key partner. How can we be a bit kind? How can we go slow when we are engaging them so that we don't disrupt your business flow? But some of these people who will lead you to your grave without you knowing. So that's why I'm mindful that the more you see people shouting on the media for every TV interview, it has nothing to do with their professional work. At times, it has a lot to do with their love for TV. But professional work is done at a personal level. It's done by people that you trust, that they are telling you the truth. They are not up for just securing their bag for you as a business person. So for professionals, wherever we are not trying to be the best on TV. That's not our case. Ours is to see you that after that dispute, you go to sleep and tomorrow you're a happy person. Your business is still continuing without major disruptions because disputes always have disruptions. But how you manage them is what is going to set you apart from others. Not every quarrel should end the marriage. No, you must work with each other. So I think, Mr. Moses, that you are back. I hope I have answered your question.
Okay, thank you very much. We have spoken, and we need to invite our audience to ask some questions. So allow me ask one last question, two in one actually. about 35% of our members are exporters, SME exporters, large-scale exporters. So these are people who trade across the region, across the continent, across seas. Do these services apply even outside Uganda? If they have a dispute with a partner in Dubai and elsewhere, can these disputes apply? Then two, a number of our businessmen are lay people who may not be able to speak the formal language of court, which is English. Can we arbitrate in my mother tongue, Ateso? Can we arbitrate in other languages besides English?
Yeah, Mr. Moses.
So our members, you could prepare your questions in the chat and also raise your hands if you have questions so that we give you an opportunity to ask questions. Thank you.
Mr. Moses, on the first one, I think our discussion has been a bit clear. We have answered it by saying arbitration works very well with the parties that have contracts, even if it's cross-border business, as long as there is a contract and you have put your dispute resolution clause to be an included arbitration with the technical team, the technical person who is drafting that clause, they will put in other ingredients that go into a dispute resolution clause that will even safeguard jurisdiction issues. That since you are in this country and I'm in the other country, there might be some bit of conflict of laws. But that goes to the quality of lawyering you have hired to safeguard you from that future dispute when they are drafting a clause. So even if you are doing cross-border business, we do arbitration. That's why you see, if you have been following news, as you said, your membership follows news, we have a URA case with, I think, Total Oil Heritage, where they have had to arbitrate in London. Yet the business key area is in Uganda, the oil fields are in Uganda, but the parties feel comfortable and safer that for me to arbitrate with you, Uganda, I would want to do it in London. That is more of, and remember, these companies come from, they don't originate from Uganda, so they are foreign parties with arbitrating with our indigenous entities. So arbitration will work well. Just get yourself the right skill set to guide you. If you don't have the skill set, you can walk to the CIAB offices and engage, and you'll be guided. Now, the issue of language, still when we're drafting the dispute resolution clause, we also agree on language. Arbitration can allow you to have the agreed language you want, so long as both of you, the parties, agree on it. Now, the duty is on the technical person you have hired to also be conversant in that language. You are not limited. But I would want to go back to the issue of why we are doing business. Oftentimes, we do business for profits. In my engagements, I have had the opportunity to travel to China. You reach the Chinese setting, they will not know much of your language, but you just pull out the calculator, you do the figures, and you agree on what you have wanted. They might have a little bit of English, people that speak the English language. Now, but still, you get to see that there is a level of engagement, even if it's informal, we agree. So for us that have studied this expertise, with the faces you are seeing here, we are Ugandan. By virtue of us being Ugandan, I expect you to understand that language should not be the issue. We can engage you on any of our languages. Where we have limitations, that's why it is important that when you are coming, you come around with a lawyer or a legal advisor, because your advisors, where we are not, they will explain some of these things in a simpler way. But even as arbitrators, when you come to arbitration, the unique thing about arbitration is that it is a party-led. When you walk to any arbitrator, they must be informed or must be alert that the key party, the decision maker, is comfortable. And comfort starts with them being able to understand what is going on in the arbitration room. So if you get to realize the client has the language limitation, you must we shall find a solution to salvage that limitation. So what am I trying to put across? That arbitration is highly flexible. Why is it flexible? It's trying to appeal to the timeliness of business decisions that businessmen have to make. That you as a business person, time is money. And time is money in the sense that you must get a decision and the right information as soon as possible, but with the right person and with the right information. So language is not going to be a problem, that I assure you. Your being not educated is not a problem because we are trained to assist our people. They don't, when you go to hospitals, they don't ask, are you educated so that we speak English? You know, they are there to serve anyone that has come to them seeking a service. So please feel free. What is key is your capacity to afford. The rest, leave it to what? To the technical people. Be sure that you are the right entities or the right parties are addressing your issues. But informality is not a problem, Mr. Kwaringa. As I will give you comfort, majority of the Chinese who are running the biggest export and import around the world, they are not that educated, but they are conversant in their language. And for those of us who deal with them, whether technical or not, we serve them and we get things going. So language and going to school should not be a limitation because it's also not a qualification for doing business. The qualification for doing business is having capital. The rest is for you.
Okay, thank you very much, Isaac. And Lillian, at this juncture, allow me engage our audience. We had hoped to use 1 hour for our engagements and then 30 minutes for our audience. But allow me engage. I saw Philip Kaheru initially. You seem to be wanting to say something. I've not seen a hand up.
Hello. Hello, Secretary General.
Yes, please.
This is
Yes,
Lucia.
Maganda Florence. Please proceed.
Lucia. This is Lucia Namumiru.
Yes, Madam Lucia.
Okay,
Thank you for joining
so
the
much.
call.
Thank you for inviting me. Now I have a question. I'm called Lucia Namumiru, and I have a company called Luna's Enterprises Uganda Limited. I'm a manufacturer of sweaters. I would like to know how arbitration can help me. For example, I get contracts from schools because I make school sweaters, and I get contracts. See, they give you a contract, and sometimes after supplying the sweaters, the schools or maybe the head teacher, they fail to pay you on time. They can even take maybe 7 months. Someone doesn't show that he's going to pay you. Now, can those arbitrators help me? And I also want to know what is the difference between arbitrators and lawyers? And another question, what about the charges? Because we know lawyers' charges. You might want to bring the lawyer to help you. And like us, small scale businesses, I can't bring a lawyer when I'm getting a contract of about 30 millions like that. They are small scale. How can arbitrators help us? Maybe what are their charges? Because lawyers' charges, mostly they are too high. So that is my question.
Thank you, Madam Lucia. Do we have any other question? So Isaac and Lillian, as you prepare, I had seen earlier Phil. Did you want to say something, Phil Kaheru?
Good afternoon, Sir Moderator. Thank you very much. I just wanted to agree with the members, the panel, who have been ably telling us about arbitration. Thank you so much. I really don't have anything to add to that for now, but thank you so much for this webinar.
Okay. I see someone in the chat saying, okay, someone is saying, tell us more about SIAB because these out of court settlement options are the way to go. So tell us more about SIAB. Someone has asked. So Isaac and Lillian, please respond to that as we wait for more questions.
Yes, thank you for the question. In regard to the charges for arbitration, as Isaac earlier stated, it depends on the subject matter. And the beauty with arbitration is that there is room for negotiation, depending on each case has its own tenets. So you cannot outrightly say that this is the amount that is chargeable for any arbitral matter that has been brought before an arbitrator. But also arbitrators are governed institutionally, and there are regulations that are set out, and you're not supposed to go above, or you can go below, but you can't go above. And this is because, just like SIAB, the reason they give regulations on fee structure is because they are aware that this is a business, it's a business matter you're handling, and it should not stifle anyone's business. It should be affordable so that everyone can access. So to answer your question, the charges are not, they are not a put-off. You will agree with the arbitrator. There's even room for you to mention that, you know, this is what can be paid for now, initially, and then the rest can be paid later. So it is not first pay all the amount, then we proceed. Sometimes institutionally, yes, but where you've appointed, the parties have appointed themselves that arbitrator, there will be room for discussion. So at SIAB, we're aware that these are businesses, and our job is to ensure that money is not stuck. And we ensure money is not stuck by making sure that we have a fee structure that fits within the subject matter that has been brought to us. So, we cannot mention that this is the amount we'll be paying. It depends on each subject matter that has been brought. And you did say that you always have contracts with schools for supply of sweaters. We would like to implore you to speak to your contractors to include an arbitration clause. We can issue an arbitration clause right up to your community so that they can avail it to you. Always include it in the agreement. And once it's included there, it will be easy for SIAB to help in arbitrating your matters. Because if you draft clauses and you're specific that they should go to SIAB, because SIAB has the expertise and the membership that can handle that, it becomes easier. So we can avail you freely with the clauses that are good to be included in the arbitration agreements so that you consider them when you're drafting your contracts. Thank you, Moses.
Okay, I also see Elijah's hand up. Elijah Basaza. Elijah Basaza, go first, then we shall hear from Nanza.
Thank you, Moses. Can you hear me?
Although you're a bit low.
Can you hear me now?
Yes, we can hear you now.
Okay, thanks for the moderation, and thanks to our panelists for the insights about SIAB. I have like two questions. One, I would like to state my background. I'm a surveyor by profession, and I would like to join SIAB. So what are the procedures? How do I join SIAB? When is the next intake for the membership? And what are the costs incurred by someone who wants to join SIAB? The other question is, do we have a public access of the cases or disputes resolved already by SIAB Uganda chapter? Those are my questions. Thanks.
Okay, thank you, Elijah. Nanza.
Thank you, Moses. I just wanted to make a supplement to Lillian's response to Lucia. One, as a business person too, who has done business with government and schools in the area where she's doing, which is school uniform supplies. Madam Lucia, I am with you and I understand, but also most importantly, as for a practitioner in the procurement space, and also in the ADR space, in the alternative dispute resolution. The school procurement systems, at least in Uganda, Madam Lucia, if you are supplying government schools, that is, let's start with government schools, that is where they do a lot of contracts and all the big tenders come from, are governed by specific rules in the PPDA has rules for schools specifically. So Chitegeza in the case of a dispute in a contract initiated by PPDA, under which I believe Madam Lucia is supplying, if she's supplying government schools, the dispute clause on how they'll resolve disputes is already embedded. My advice would be that at the time of contract drafting or signing, before she signs, now that she knows, she can guide where she's given the contract, and they say in case of dispute, we shall go to court or whatever method they put. She can now be the proactive person to ask for mediation or arbitration as opposed to court. Now that she's fully aware, Bebamwa contractor, she should be the one to see that dispute clause, because PPDA contract forms stipulate how disputes will be resolved. At the point when the dispute has arisen, it might be hard for her to go back. If it is the private sector, I believe in a contract clause. It's just her using this knowledge at the point of contract signing to safeguard her interest, given her track record with these clients. So, Madam Lucia, I feel you, I understand you. I've supplied school uniforms, I've worked in the public procurement sector, and now I'm an ADR practitioner. So sometimes prevention is better than cure. Thank you very much.
Okay, thank you, Nanza. I see Lillian and Isaac. I hope you've noted Arthur's question. I see Donald's hands up. Donald?
Thank you, Mr. Moderator. Good afternoon to everyone on this call. My name is Bejira Donald Sharp. I am a lawyer by profession. I practice my trade with Credo Advocates, but I'm also a businessman. So my question really revolves around the anatomy of arbitration agreements. You find that most of these technical persons, really, that Mr. Sekabaja had alluded to, that help in arbitration, they also use it sometimes to perpetuate injustices, especially when it comes to, let me say, one is representing a large corporate entity and they're an employer. I've seen an instance where there was an arbitration clause which required the employee to waive their right to an industrial action. So in just that clause itself is an injustice to an employee, but you find it's being perpetrated by the people that we look up to, the technical people who know this arbitration. So with regards to the business community, I would like to know what the Chartered Institute is doing in as far as creating awareness or talking to its membership, because some of these ills are actually brought in by the membership. You find people are representing big clients and they'll just work around these agreements, work around these clauses, and the common person won't understand what they are entering into. Thank you.
Okay, thank you, Lillian and Isaac. As you're answering, someone had asked for the number of Nanza. Nanza, please put your contacts in the chat, but also Lillian and Isaac also put in the CIAB contacts in the chat.
Now, Moses, I will start with Donald. The problem we have when you come to us that do arbitration on a daily, I will tell you one simple reality that we face. that as much as some of us labor to do good work that is professional, as we are taught, but in this country, we are suffering with a reality of intellectual dishonesty, where some people are very dishonest to a level that as long as the side that butters their bread tells them to do something, they will do it. Now, for me, how do you safeguard against that abuse? Is that you on the other side, they are trying to manipulate. You should also come with competent skill set to speak back with that. But the problem we always have that as much as you get to hear in here, our community wants to earn money, make profit, but without planning for conflict. And what usually happens is that once you don't plan for conflict, you would want to think that everyone is an angel. You go, you receive that contract without having your own lawyer. You think because the company you are dealing with has lawyers, they are looking out for your interests. No, please let us be a bit candid on this. It takes two to tango. And if you come when you don't have someone on your side to speak to the other technical person, you are likely to be having a lonely path. So as much as you are SME or you are small, please, even when you are small, people can understand. I usually tell people that how us professionals, how lawyers build clients, we don't build clients to kill them. The Chilumila of today was once a beginner, and their lawyers he interacted with at his start. They built the relationship, and over time, they are still his lawyers. What does that show you? That we as professionals, when you come in, we grow with you. We must, intellectual honesty demands that you assess your client and understand that, yes, I'm giving them a service, but the capacity to pay is at this level. But if I give them time, they will be at another level and they will be able to pay. That is how things must work. So please, the issue, some of these things we don't have control over them. It goes to the level of vigilance. We go and get people to be trained. We train them. And I want to assure you, even if it were yourself, if the other side demands that ABCD be done, and the other side is not vigilant enough, you are wasting time. So let us also own up on our part of mistakes, where you enter into contracts and for you play victim. Business is not for playing victim. You must be solid on your side as the other side is also solid. Where you are not, you'll be manipulated. There's a person that asked about matters to do with SIAP, Uganda chapter. Please, our SIAP coordinator is on this chat, on this call. Please, is going to share numbers and the next available trainings we have. If you had joined earlier, we have actually been showing the next available trainings. But we also have social media handles where once you get to on all platforms, more so the professional platforms, I should say, that is Twitter and a bit and LinkedIn, you can actually easily engage with us and we get back to you. Or I need to also get you back to Madame Lucia's question, because that's one thing that I've sensed many have. Madame Lucia, I would want to tell you that, as I said, that your level of exposure is very important when you are dealing with certain people. The moment they get to see that you are not as alert as they would want, as you should be, you are going to be abused. Now, what does that mean? That the lawyers that you fear are there to save you. But please also find a lawyer that is affordable to your demands. Not all lawyers are expensive. And all of us are in lawyering, we are doing business. The unfortunate bit is that you at times we have the problem that we face, that as much as the business community is bidding highly, they want the other people to do charity. No, that is not going to happen. So work with them. But the other important thing I wanted to show you, and most of my arbitrations I've done, the people that have small contracts, there is a contract, it is written, they have delayed it to pay. I want to assure you, those are people who have walked in and left the very day or 2 days they came with a consent. The consent to the effect that I'm willing to pay you in 3 months in these installments. That consent is an arbitration award in itself. But the beauty it has, that it works as a judgment that is already handed down. The moment that person fails to pay the money as they had agreed, you will walk to court and enforce that consent. Now, the explanation, the timelines when you have an award are shorter than when you have a plaint and the other person has to defend. So for me, I usually say that what arbitration does for a business person is it shortens the process, but also it gives the other party the opportunity to tell you the reasons why they are not paying on time. And then you tell them, now, since you are not paying on time, can we give you ourselves a timeline? And then it's an engagement. Through that engagement, we create a consent. Oftentimes, such small contracts, you get to see even arbitrators where it's applicable, someone billing you as low as 2 million, 1 million, depending. And this cost is not actually, but it's not only on you, Madam Lucia, it is a shared cost. The other party pays some money and you also you pay, because you both have a duty to hire a lawyer, to hire an arbitrator. Now, the reality of things shows us the difference between arbitrators and lawyers. It is important to understand that arbitrators are, the qualifications are very many. You can be a surveyor, but an arbitrator. You can be a lawyer and an arbitrator. So you just get to see arbitrators who are lawyers at times. But you also have arbitrators like Nanza, who are not lawyers, but they have a procurement background. They have studied their procurement, they have done business, and because of the procurement background, they realize there are always procurement disputes. And how do I arrest them? Let me get a skill set in resolving disputes without having to go to court. The level of engagement we need is a bit of formality. So lawyers are lawyers, but also it's always lawyers, because they are used to disputes. You always find them trying to hone their skills into arbitration, because by nature of lawyering, you are always in the conflict arena. So arbitration will be a walkover, but it does not mean that lawyers are the same as arbitrators. No. That's why I'm actually happy that you have people like Nanza here who have spoken to show you that we have people from different backgrounds. And we also have someone here who wants to join. That's Elijah, who is also a surveyor. That goes to show you how broad the community of arbitrating is. But I also want to tell you that arbitrators can also be your reverend in the village, can also be your archbishop of whichever church you come from. So we are not limited in sense of even skilling. It's about the parties agreeing that I feel like for me, if Bishop so and so is the arbitrator, I'm comfortable. Now it's up to Bishop to also on the sidelines to hire a lawyer to help them in some technical, but they will still be able to arbitrate because that's the person we want. And why we are SIAB is here and we sit as SIAB is that for us, we have made it a case in improving our skill set so that when you come for us, the value for money is different. The process is a bit faster. So don't try to be scared about the money. You can actually come by yourself as Madame Lucia, walk to the center if you have an argument, and you might not need a lawyer. Because we are also allowed, it's not a must that if you are doing an arbitration, you must hire a lawyer. Let us also get that right. You as a party, as long as you have an arbitration clause, you can now start your process. Mr. Moses, I'm done. Unless Leon has something to add.
Okay. I'm glad we still have a full audience. Members online, do we have any other questions? Over to you, clarifications, inquiries. Okay, we could use the next 5 minutes for you to give us more information. If I want an arbitrator, what do I do? Do I call? Do I physically come to your office? What do I do?
If you want an arbitrator, yeah, SIAB has the mandate to appoint arbitrators for as long as the parties have included them in their agreement. There should be a clause that is specific to that. So SIAB is an institution. It is poised with qualified arbitrators. So when you write to SIAB, they'll be able to respond and give you a list of arbitrators available, and then the parties can choose. Either you can have one arbitrator or a tribunal. It depends on the complexity of the matter. I would also like to let the members know that criminal matters are not arbitrable. So in mind, just know that it is usually commercial disputes, employment issues, consumer disputes, financial disputes, and environmental disputes, among which that are arbitrable. But for criminal matters, they are not arbitrable. So they shouldn't be thought about as one of which can be arbitrated upon.
I would also want to add on what Ian has talked about, that you can come to SIAB. That is one entity that you can come to, and we are growing ourselves into a branch very soon. And also, according to the memorandum of understanding that you shall make with your entity. Mr. Mario, can you? Yes. Now, we have other arbitration institutions. Lillian mentioned the CADA, we have ICAMEC, and we have Praxis. Now, some of these institutions have their mandate within the law as appointing authorities. If you walked to them, it is important that you don't just go there without the contract. Remember, ours as an arbitration matter, it is embedded in your contract or a form of agreement that you agreed with the other party to arbitrate. So once you have that contract, wherever you take it to those institutions, they will review it. The other, how do you get an arbitrator? You might say, the Secretary General of National Chamber of Commerce is a person I want. And you might walk to them and tell them, Mr. Secretary General, this is my contract. I want to appoint you as the arbitrator. And then you tell him, I'm going to write a letter to the other party nominating you. The other party agrees that, okay, let's use the Secretary General. You are good to go and you start with. But remember, before you arbitrate, you must be informed that there is an arbitration agreement. That is what gives the arbitration locus to exist. And then the rest is easy. Moses, there is also, I think I've answered also Raymond's question in the chat.
Okay, members, the SIAB runs various programs throughout the year. They have a training calendar. So they have a training on, is it the 14th? Isaac, please throw more light on the training of the 14th for those who can attend. 14th, 14th, 14th. 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 14th.
I'm going to call up my CIAB chapter person here to speak more to the trainings. Please, the person at the CIAB chapter behind there, please open up your mic and talk to the members.
Can you all hear me?
Yes.
Yes, good afternoon. Thank you, Moses, Lillian, and Isaac, for a fantastic job. And I know that members of both CIAB and Chamber of Commerce have found this very insightful, and this is a beginning of a great relationship between the two entities. My name is Anne, and I chair the Education and Training Committee of CIAB Uganda chapter. So as Moses has mentioned, we have two trainings coming up. Very many people asked, what is CIAB? What do you do? How do you become an arbitrator? And all that starts with knowledge. You cannot do all these things when you don't have knowledge. So we have a beginner's course. I would like to request Bridget to put up the flyer for introduction course. Bridget is the administrator. We have an introduction course that is coming up on 4th December. Yes, the training will be held on 4th December. Contact Bridget for further details. It will introduce you to what arbitration is. That is for the people who want to practice arbitration. It will introduce you to what it is, and it is the beginner's course. It will be held on 4th December. And then we have, yes, Bridget is sharing screen. Those are the details. You can contact her. So 4th December is the day for the training, is the day for the assessment or tutorial, where you will have a member guide you through. And then in a month's time, you do the exam. So the procedure is you register, you get the book because it's self-study. On 4th December, you have a tutorial. Then within a month, you will have the exam. And I would recommend it to everybody, everyone online who wants to practice arbitration. This is the fundamental course for beginners. Now, when you have finished associate course, you will go, as we later on engage with the chamber, we shall be sharing all these programs. We've just finished a membership course, which is the second level. Then the third level is fellow course, and one of our panelists is a fellow, Lillian. So as a precursor to being a fellow, it is most important that you practice your skill of writing awards, because as an arbitrator, when the matter is brought before you, after that you are supposed, after that you're supposed to write what we call a decision, and the decision is called an award. So we have a training in award writing. That is for people, I would recommend it for people who have some manner of knowledge in arbitration. We have a training on award writing on 21st and 22nd November. I request Bridget to put up the flyer. That is our next training. It's being conducted by the most seasoned experts in the field of arbitration. Two fellows are conducting that training. I would like to urge us all to attend, to spread the news, because it is not very easy to get these two persons at the same time to give you 2 days to train you from the A to Z of what arbitration is. You don't start with award writing, you start with understanding the arbitration agreement. There have been many questions about the arbitration agreement. How do you draft a proper arbitration agreement? So this training shall cover everything from understanding the agreement to drafting the award. It is intense, it is 2 days, and it is on 21st. Bridget, please put up the flyer. It's on 21st and 22nd of this month. We shall have more trainings next year. By end of January, we should have released, and that's the arbitral awards training that is going to be held. Seasoned people, the best you can ever find, please make time and attend it. We shall release our activity calendar by end of January, where we shall have a series of so many activities, webinars, events, collaborations, more collaborations with the Chamber of Commerce. So please follow us on all our social media handles to get all those, to get our training calendar. And we shall include topics of how to draft a clause. There have been questions of what if the clause is defective? Okay, that was not the question. The question was what if it contains something that is restrictive? We shall talk about defective clauses. We shall talk about the different kinds, because arbitration is just one mode of dispute resolution. There's mediation, there's negotiation, there's dispute avoidance. So we shall have so many trainings. So please follow for that. And now for our members who are already members of CIAB and are on this call, we have a networking event for all of us on 6th December. I asked Bridget to put up that flyer, networking event for all members, even non-members. You can come and interact and network with members and ask them how did you become a member of SIAB and what does it take to be a successful arbitrator? I am a beginning arbitrator. What should I do? So we have a meet and greet event on 6th December. Details, please follow our social media handles. So as Bridget is putting up the flyer, that is it. Please feel free to contact her. She's our administrator. She has shared her number in the chat, and looking forward to more insightful discussions. Over to you, Moses. Have a good evening.
Thank you very much, our partners from SIAB. And
Just something small, Moses, that I didn't mention. SIAB, I know Isaac and Lillian touched on it, but SIAB is not only based in Uganda, it is an international, the headquarters are in London, and it is the gold standard for everybody who wants to arbitrate in the world. You will usually be asked, are you registered or are you a member with SIAB? So I would urge all of us here to become members. All the people who want to do arbitration, please become members of SIAB because it gives you some manner of recognition worldwide. I see there is Miss Tina Banda. She's joining us from Zambia. She's a fellow and she's joining us from Zambia. Tina, you're welcome. So you can see that it is really international. We have people from all over the world who have tuned into this webinar because SIAB is the only accredited gold standard in the world. That's what I wanted to add. Thank you.
Okay, thank you very much, our partners from SIAB, Lillian, Anne, Isaac, and the rest of the team. Bridget.
Moses,
yes.
before you conclude, I felt that I needed to say a key point. As much as we've been having this webinar, I think it's important that also your membership, that you can get to that have a bit of formal training and they have capacity to come and take on these trainings. It would work for their benefit because even us as SIAB, we usually want to work with the coalition of the willing. If some of your members came and took on our courses, it will even be much easier. They will be there, like how Jesus had his apostles. They will make it much easier for us. But for now, we are speaking and we appear like we are outsiders. It will be easier for your membership that is within you, that are well trained. When they speak to your people, we shall not actually be laboring with some of these things. So for me, it's a clarion call to some of your members that have some formal trainings. Skill set is all you have. Grow yourself. So please invest in yourselves as you invest in your businesses. Thank you, Moses.
Okay. Thank you very much. The team from SIAB, our members online, thank you for waiting throughout and being part of this engagement. This is only the first of very many, and we hope to continue doing the same. So remember, thank you very much. SIAB, thank you very much. And we look forward to more engagements in the future. Have a good afternoon.
Thank you for having us.
Thank you for having us.
Thank you.
Thank you.
Thank you very much. That's all for this meeting. God bless you.